Vanakkam. Today I am going to take a very interesting topic called acquisition and transfer of immovable property in India and out of India. Most of the people they used to ask that, sir, I am resident outside India. Can I buy the property in India? I am a foreigner. Can I buy a property in India? And somebody used to call and ask that, sir, I am a resident of India, but I want to buy a property outside India. What are the procedures that I have to follow? Here in today's presentation, I am going to take up the very interesting topic, and as well as I am going to tell the highlights of the provisions that are related to acquisition and transfer of immovable property in India and outside India. And before going to the presentation, I want to say my disclaimer that the views expressed by me is my view only. For clear understanding, I request the viewers, please go through FEMA 1999. I am not responsible for any wrong interpretation. With the disclaimer, I am presenting the subject for your easy understanding. Let me go into the topic. Capital account transaction. Yes, acquisition and transfer of immovable property by residents outside India. And if he wants to buy a property in India, or if he wants to transfer the property, and as well as the non-resident India. So here I use the word resident, Indian residents outside India, non-resident in India, and all are related to the capital account transaction. That is, the acquisition and transfer of immovable property is related to capital account transactions. Hence, the transactions are subject to scrutiny or under the direct control of RBI. Now, sale or gift of property in India. Yes, a foreigner is not, suppose a foreigner, he wants to buy a property in India. Is it enforceable? No, it is not enforceable. And RBI specific permission is required for it. So next one is acquire the immovable property by NRI and overseas citizen. Previously it is person of Indian origin. Now it has been converted into OCI in India. Acquire immovable property in India by NRI and overseas citizen of India. So what are the permitted thing? Yes, any NRI or OCI can buy any immovable property in India. But there's some restriction. That is, they are not supposed to buy any agricultural land, farmhouse, or plantation of property. Plantation property they are not supposed to buy. So this is a basic condition. Yes, immovable property can be purchased by NRI or OCI, but this cannot be other than the agricultural land, farmhouse, or plantation property. You can do the purchase. Now, from where you have to get the money? So there are some permitted source and not permitted source. So this NRI can bring the money into India to buy the immovable property other than the agricultural land, farmhouse, and plantation property out of funds received in India through banking channel by way of inward remittances from any place outside India, or funds held in non-resident account maintained India. That means the fund has to come by way of forex to India. In the account which the non-resident is having the account in India, it may be the fund would have come outside India by way of forex. So from that, it is permitted, you can buy it. But from the following sources, you are not supposed to buy any immovable property. One is you cannot use traveler's check, that is non-resident or NRI or OCI, they are not supposed to use the traveler's checks and foreign currency notes or any other mode other than the permitted source. Permitted source are allowed to be used to buy the property. Here, can NRI or OCI acquire by way of a gift any property? Yes, it is also possible. But acquire a gift by way of gift from a person resident in India, or from an NRI or OCI who are relatives, it is permitted. Immovable property other than agricultural land, farmhouse, or plantation of property. Their main concept is the agricultural land, farmhouse, and plantation property should not go into the hands of NRI or OCI. This is a basic concept. So suppose by way of inheritance, can NRI acquire? Yes, it is permitted. Acquire by way of inheritance from a person resident outside India or from a person resident in India, it is permitted. Yes, an immovable property can be acquired by NRI or OCI, and all immovable properties here the NRI or OCI, they acquire the property by way of inheritance. If it is in the form of gift, not allowed. If it is form of purchase, it is not allowed. But by way of inheritance, it is allowed. All immovable properties, including agricultural land, farmhouse, and plantation property, and NRI, OCI can acquire. So, by way of purchase, by way of gift, by way of inheritance, you have acquired the property. Now, this NRI wants to sell it. That means he has to sell the property to someone. What are the procedures that you have to do it? So if they transfer, NRI or OCI transfer any immovable property to only that is, they are eligible to transfer only to a person resident in India. And if they want to transfer NRI or OCI, it is also permitted. So one thing is, if at all they are having agriculture and farmhouse or plantation property which they acquire through inheritance, they can transfer the property to any resident. It is permitted. In case if NRI or OCI they want to transfer to another NRI OCI, yes, it is also permitted. You can transfer it, but other than the agriculture, farmhouse, plantation property. This is a main concept I have already said. So NRI and OCI are permitted to hold immovable property other than the agriculture, farmhouse, plantation property. If they acquire through inheritance, yes, it is permitted. In other sources, it is not permitted. In case joint acquisition of property of NRI, suppose NRI is that, or OCI is that her spouse, they want to buy the property. Yes, spouse, who is not, the spouse should not be NRI or OCI. And the spouse is a resident outside India, but she has not become the NRI. So a person resident outside India, a spouse can acquire the agricultural property, acquire the immovable property other than the agricultural property, farmhouse and plantation. But it can be acquired jointly. Those properties can be acquired jointly with his or her spouse, her NRI or OCI spouse. So spouse is here, NRI is here, they can jointly buy the property. If they jointly buy the property other than the agricultural land, other than the farmhouse, other than the plantation property, joint purchase is allowed. And the only one condition they put that the marriage should have been completed some 2 years back. So that is, marriage registration is a must one. That is a condition they put, and the marriage registration should have been done 2 years earlier. So that means only the spouse who has got a marriage of 2 years and above, they are eligible to buy the joint acquisition of the property. And if the spouse is not resident, not a resident, if the spouse is not resident, then it is prohibited transaction. Now, from where the spouse has to get the money, it is permitted source are funds received in India through banking channel. It is allowed by way of inward remittances from any place outside India, as well as the funds held in the non-resident account maintained in India. From that, they can buy the immovable property. That is, it's due to joint acquisition of property. And the non-permitted sources are traveler's check, foreign currency notes, and any other mode other than the permitted source. They are not allowed to use that fund to buy the property in the joint name along with the spouse and NRI or OCI. Now, what are the purpose for which the property has to be acquired? What are the permitted activity? In case the person is resident outside India and he has already established in India an office, project office, or place of business to carry on any activity other than the license office. So suppose if it is a license office, they are not supposed to buy the house. And they are permitted to acquire any property in India, and which is because this property is an incidental or necessary to carry on such activity. So this is a permitted source. Next one is the purchase of those properties should be there, which are all subject to laws, rules, and regulation of the country that is of India to be And persons after the purchase, they have to inform RBI in form number IPI, and this has to be informed not later than 90 days from the date of such acquisition. So immovable property can also be purchased for the purpose of carrying on the business. Next one is, can this property mortgage? Yes, this can be mortgaged with the authorized dealer. This is towards getting any loan. This for the above said properties, that is the properties which have been acquired for the purpose of business, can be mortgaged with authorized dealer. And the lease of 5 years. So without permission, non-resident can, that is non-NRI or OCI can have the lease in India. No person of here, it's a specific class they are given. No person of, that is Pakistan, Bangladesh, Sri Lanka, Afghanistan, China or Iran or Hong Kong or Mecca or Nepal or Bhutan or Democratic Republic of Korea shall acquire any immovable property in India. These persons, these citizens or persons who are there in Pakistan, Bangladesh, etc., they are not allowed to acquire any property in India. If at all they want to acquire, they have to get the RBI permission. But all the above said persons can enter into lease agreement, but for a period not exceeding 5 years. This is permitted. And purchase by, suppose a foreign embassy is there, they are diplomat is there, consulate generals are there, they want to buy a property in India. Can they do it? Yes, they can purchase and sell the property. That is, foreign embassies, diplomats or consulate general, they can purchase the property, but this immovable property should not include agricultural land, farmhouse or plantation property, but which is subject to clearance from Government of India, Ministry of External Affairs for the towards the purchase or sale. But the consideration has to be paid out of the funds remitted from abroad through banking channel. Indirectly, they say that is INR should not be used to buy the property in the name of the diplomats or consulate generals or foreign embassies. Yes, sometimes a foreign national has come here, or citizen of other person, they come here and stay here, and they are holding a long-term visa in India. Whether they are entitled to buy the property, yes, it is also permitted. In case the person is a citizen of Pakistan, Afghanistan, Bangladesh, but these citizens should belong to a minority community of Hindu, Sikhs, Buddhists, Jains, Parsis, and Christians. Then they are entitled to buy it, but they have to reside in India. That is, they are residing in India, and they should have got the long-term visa granted by the central government. They are allowed to purchase one property, one house property for residing purpose, one for the employment, only for the self-employment. So that is a indirect meaning that they are not supposed to go for the employment. Suppose he is holding, they say that it's a self-employment. That means they have to do the business on their own. What are the conditions for that? They say that property should not be located in and around restricted or protected area as notified by the central government and cantonment, or person to specify the source, and the person who is buying the property, he has to specifically source from this source only. I have purchased the property. So this has to be, these details have to be submitted to the revenue authority, and nationality and the fact of long-term visa holder have to be mentioned in a registered document. Suppose if they are registering the document, in that they have to clearly mention that I belong to Pakistan and I am a Hindu. For Pakistan, I want to register my property here and I am holding the long-term visa. So that they have to specifically mention. And if the same property will be forfeited by the Indian government, if they are involved in any anti-Indian activities, that is against India, they do it, then that properties will be confiscated. Then copy of the property document must be submitted to Deputy Commissioner of Police or Foreigners Register Office or Foreigners Regional Registration Office and the Ministry of Home Affairs, Foreigners Division. So at both places, they have to submit the copy of the property document. And if they want to sell the above said property, that is the long-term visa holder, he wants to sell the
property, then he has to sell only after acquiring the Indian citizenship. And if the Indian citizenship is not obtained, then okay, that is also permitted, but they have to get the permission from either from the DCP or Foreigners Register Office or Foreigners Regional Registration Office. Then only they are entitled to sell the property. And now you have sold the property, you have got the sale. Can it be repatriated to foreign country? Yes, it is also permitted, but eligible persons to transfer is the person. Suppose if a person is there, NRI is there or OCI is there, he can do it, or his successor also can transfer the thing. But for the transfer, the RBI has already given some general or specific permission. But this repatriation outside India, the sale process of any immovable property. So only when the property has been sold and all the sale process can be repatriated, but which are all subject to that immovable property which was acquired as per the existing foreign exchange law. Other than the agricultural land, farmhouse and plantation property. So the process of sale of agricultural land, farmhouse and plantation property should not be repatriated. And the amount to purchase in the form of remittances has come through because the amount of purchase, when they purchased, the amount would have come in the form of the regular banking channel or out of the foreign currency non-resident account or out of the funds in NRI account. All these three accounts have got forex inside India. Foreign exchange comes to India. So when they want to repatriate, only when the fund comes to India through forex, foreign exchange, only that is allowed to be repatriated. And in case of the say there is a sale of residential property, yes, it is also permitted, but only for the two houses, minimum when maximum is two houses, to the value of two houses, a repatriation is allowed. So this is with reference to sale process to be transferred to the other country. Now, external commercial borrowing is availed by an Indian borrower, but he made a default. Now the foreign lender who has taken the property as security, he wants to sell. Can he be permitted to sell? Yes, it is permitted. It is permitted. The foreign lender, he can sell the property, but the process can be transferred only to the extent of loan outstanding and not for any other loans. This is clearly said here. Only to the extent of property which has been mortgaged and only to the extent of loan outstanding, the foreign lender, he can sell the property and he can repatriate the money and he can take the money from India. But the only one condition is the money should have, that is the mortgage should have been done through or only to the purpose of ECB, that is external commercial borrowing. Next is the restriction to person resident outside India to transfer immovable property. Yes, a person resident outside India, he wants to transfer. The transfer is subject to RBI specific permission. Person resident outside India, he is also entitled to transfer the immovable property, but everything is subject to RBI permission. And for this, authorized dealer, as per the direction issued by the RBI, permit the resident in India. So a non-resident person resident outside India is there. He has got a property in India. He has authorized some resident to enter into any agreement here, and they can sell it. They can create a charge on overseas lender on the property of person resident outside India while obtaining ECB. ECB is being obtained here, and the property belongs to person resident outside India, and he can create a charge in favor of overseas lender, and this charge can be done by the resident in India, and this is a permitted activity of authorized dealer and as per the direction given by the RBI. Authorized dealer in India who is a correspondent of an overseas lender subject to RBI directives create a mortgage. So authorized dealer can create a mortgage on immovable property in India owned by NRI and OCI for a loan availed or to be availed by company from overseas lender. So authorized dealer himself can create a mortgage if the loan is being availed by NRI or OCI from the overseas lender. And the fund should be used only for the purpose of the business and not for any other purpose. And in case if there is a default, that property be invoked, yes, Indian banks can sell the immovable property to an eligible acquirer. Who are eligible acquirer in case of other than the agricultural land, residents. And if they want to sell property, any immovable property, if they sell to resident, yes, they are called as eligible borrower. If the property they are selling to NRI or OCI, other than the agricultural land, farmhouse, other than the plantation property, you can sell it. So they are all coming under the category of eligible acquirer and remit the process after the sale, because there is a charge on the property. So after the sale, the property can be remitted to the overseas lender. Now, a person resident outside India, he wants to transfer the immovable property. Yes, if provided they are, it has been acquired in the regular normal course of existing foreign exchange laws, and after getting the, if there is any specific general permission of RBI, person resident outside India, he can sell the property to resident India. Say here, only the NRI or OCI, they are not permitted to sell the agricultural land, plantation property or farmhouse. But if the status of the sale is person resident outside India, he can sell. But the process should come through, that is the purchase of property should come through the banking chain. And resident in India should not be prohibited for such acquisition. Suppose any resident, if the person resident outside India is selling, that resident should not be prohibited to acquire any property. Suppose acquisition and transfer by citizen of other countries. Other countries, they are having the property here. Can they sell it? No person being citizen of Pakistan, Bangladesh, Sri Lanka, Afghanistan, China, Iran, Nepal, Bhutan, Hong Kong, Mecca, or Democratic People's Republic of Korea shall acquire or transfer immovable property in India. But this can be done with the permission of the RBI. But to enter into lease agreement by the above said countries, it is permitted. For that RBI permission is required, but the lease agreement should not exceed 5 years. And here OCI is not covered by this prohibition. So if he is a citizen, so NRI, that is a different issue. OCI, that is other citizens of India, if they are at Pakistan, Bangladesh, they are permitted, and yes, the OCI is not prohibited because of this provision. And here citizen means natural persons and legal entities. Just for clarification, I have entered into here. Here, the next part is resident is here. He wants to sell the property. He wants to acquire the property out of India. What are the procedures that you have to follow? FEMA regulates the provisions relating to residents and non-residents to acquire, transfer and immovable property out of India. So that means you are going to transfer or you are going to buy the property out of India, and all the acquisitions are subject to tax laws of the country. Inheritance rights, because sometimes this residents are non-residents, they acquire the property by way of inheritance, that is not affected because of this class. And now, resident in India, they want to acquire or transfer immovable property outside India. For this, if they have to follow FEMA 1999 or general or specific permission of RBI, then they can acquire the property outside India. These restrictions do not apply to resident when he is a resident here, but he was a foreign national. At that time, he has acquired the property, and if the acquisition of the property was done before 8/7/1947, and for that they have to, that resident has already informed the RBI, and with the RBI permission he is holding the property, then it is permitted. Then acquisition of property through lease for a period not exceeding 5 years. And ways of, what are the ways they can hold the property outside India? One is the resident can acquire the immovable properties in the following manner. When this resident at the time of hold, own, transfer or invest in immovable property was resident outside India, inherited from a person resident outside India. So today he is a resident in India. He has sold the property when he was resident outside India, and whether he has inherited the property from a person resident outside India. Sometimes you would have got the property by way of a gift. Sometimes he has purchased the immovable property out of foreign exchange held in his resident foreign currency account. And this sometimes, whether they are permitted to hold the property in joint acquisition, yes, it is permitted, but with the relative who is resident outside India, but there is no outflow of funds from India. Yes, he can acquire. The resident can go and acquire the property outside India, but he can hold in jointly also with a relative outside India, but there should not be no outflow of funds from India. This is a very, very basic thing. That means the forex should not go India to the other country. Then the relatives here, it means it is husband, wife, brother, sister, or any lineal ascendant or lineal descendant of that individual. And sometimes LRS, liberalized remittance scheme, that is, one can use the fund in NRO account to the extent of 250,000 US dollars per year, per financial year. You can transfer. The person should be resident individual. By using LRS method, you can acquire the purchase of immovable property outside India. Another thing is, suppose companies, they are having offices outside India, whether they can acquire it. Yes, it is permitted, but the company should be incorporated in India. But you should have overseas office. The company is here, you should have the overseas office, and they are permitted to acquire the immovable property for its business and for its residential property. But the property, if it is being purchased for the purpose of residential, and it should be used only by the staff. This is what I want to say about today's presentation. It's a very, very interesting thing. There are a lot of questions you will get. You are welcome. And with this, I'm just closing today's presentation. Today's presentation, I have covered immovable property purchased in India by NRI or OCI, person resident outside India, and resident and non-resident, if they want to buy a property outside India, that provisions also I have covered in today's presentation. I wish you all the best for the purpose of this transaction, and thank you very much for the patient hearing and patiently watching today's presentation. Nandri, Vanakkam.